Please begin, Ms. Evans.
May it please the Court, my name is Sol Evans, and I too am representing with the petitioner the City of Amherst and the Commonwealth of New Columbia this evening in asking this esteemed Court to reverse the decision by the Supreme Court of New Columbia and to find that the juvenile curfew ordinance of the City of Amherst is constitutional, both valid, justified, and necessary. Your Honors, the City of Amherst is literally engaged in an all-out war in fighting a rising epidemic of crime, death, and drugs that is killing and poisoning our youth, our children, and our future. The juvenile curfew ordinance of the City of Amherst is one of the answers to a complex and disproportionate problem that is affecting juveniles. And it is constitutional because, one, it does not discriminate on the basis of a suspect class, does not show an intention to discriminate, and therefore meets the rational basis standard of review, in which this city has undeniably shown a legitimate state interest to reasonably restrict the rights of Mr. Hoffman and juveniles all throughout the city. And that, two, as the ordinance now stands, it is already showing signs of becoming an effective deterrent against this rising epidemic of crime. And it, most importantly, is showing signs of saving lives. Now for our argument. The first rule, Your Honors, has been set by this Court in Washington v. Davis in 1976, when this Court held that a higher standard of strict scrutiny had to be applied when both a disproportionate impact and disproportionate intent were shown to be discriminatory on the basis of a suspect class concerning race. The opposing counsel, what we are saying, Your Honors, is disproportionate impact has already been shown, not because of discrimination, but simply by the mere fact, Your Honors, that as the record shows on page 35, 60% of this city is African American, and yet only 38% of the city is white. If it rained, Your Honors, more African Americans would get wet than whites. I would furthermore argue that any law, any ordinance passed by this city council would undoubtedly always disproportionately affect Africans more than their white counterparts. And by doing so, the only thing that opposing counsel has to do to show that it violates an equal protection clause is that it also had a disproportionate intent. What we are arguing tonight, Your Honors, is that it does not.
Wait a second. You concede then that it does have disparate impact on black youth or African American youth. What is the discriminatory intent?
The discriminatory intent
lacking
is the second requirement, is the second standard that needs to be applied to show that there is a violation of equal protection, Your Honor. And we're saying that it does not. The juvenile curfew ordinance was written with the Constitution in mind. On page 42, it states that it was written to uphold, it was written to meet constitutional muster. On page 55, it even says that an outside law firm has already looked at the ordinance to make sure that it met constitutional muster.
But whose intent are we concerned with? And isn't there something in the record to the effect that some of the councilmen that actually proposed this had a discriminatory intent in some of their comments and their direction?
Absolutely not, Your Honor. If you look at the record on page 50, I think you're referring to Councilmember Marshall's comments. His comments, first of all, are 1 out of 14 members, in which in Hunter v. Underwood, this Court said that not one legislator can influence or be the motivating factor of other legislators.
If we knew that about all of them, would that have a different effect?
Obviously so, Your Honors, but in Arlington Heights v. Metro Housing Corporation, this Court said that we must be sensitive. We must be careful in looking at legislation. Mr. Marshall's comments about Region 3, we must look at the record on page 75. What he is stating is his region only had 1 juvenile murder in the last 3 years. Regions 7 and 8 had 70 juvenile murders. It's not because they're black. This city is 60% African American. There are many African Americans that live in all 7 other regions. But it is because Regions 7 and 8 have the majority of the federal housing projects. So if anything, Your Honors, this ordinance discriminates on the basis of class, not color, which has been upheld by San Antonio v. Rodriguez by this Court in 1973, that discrimination based on wealth can be justified if it shows a rational basis standard of review. It does not have to meet the higher standard of review. And that's what we're saying this ordinance does. It does not discriminate on the basis of color, and it may discriminate at the most on the basis, it does not discriminate on the basis of color, and at the most it may discriminate on the basis of class. What we're also saying, Your Honors, if you look at the record on page 69, Mr. Biner's comments, again, we must apply Arlington Heights, and we must be sensitive. If you look at that page, you will also see that he retracts his statements, stating that what I meant to say, Councilmember Riggs, is that this ordinance applies to all minors. And on page 7, he goes even further to say that I want to retract any insinuation that I might have made that this ordinance would be discriminatory or have discriminatory intent. If you look at the other exemptions that failed, For example, the car exemption, which I know opposing counsel will say is an inference to being racist. We are again saying that it is not, and that it is justified, and that, as the record says on page 51, as Councilmember Marshall says, there is a tremendous amount of activity concerning prostitution and crime outside of bus stops. There's nothing in the record about crime and prostitution outside of cars. There's nothing about drive-by shootings. There is something in the record on page 51, though, about prostitution, crime, and drugs outside of bus stops. I would further add, we regulate public transportation all the time. In this city, at 12 o'clock, guess what? The streetcars, the buses, they stop running. But if you're a private owner of an automobile, you can drive that automobile any time of the day or the night. So what we are saying again, if anything, this ordinance is justified because it's discriminating on the basis of class and is justified in doing so, and is not discriminatory on the basis of color. As for the 150-foot exception, 150 feet from one's house, which was also struck down, as the record shows on page 66, the reason for it is because the record shows inference that the majority of the murders that are happening in this city are happening outside apartment complexes. And to infer that the majority of the African Americans, 378,000 citizens are African American in this city, all are poor, all walk, don't have access to cars, and live in the projects is ridiculous. Just as ridiculous as to say that all the white citizens, all 230,000, have cars, affluent homes with 200-foot yards, and do not live in the projects. This ordinance will discriminate against the poor white just as much as it will discriminate against the poor black. It will benefit the affluent black just as much as it will benefit the affluent white. So in conclusion, Your Honors, to those that say that the juvenile curfew ordinance is not showing signs as an effective deterrent, and that the percentages have only dropped by 1% over the last year for the quarter for arrests, and by only one less kid killed on the streets of Amherst, to them I would respectfully say, over the course of a year, Your Honors, that's 4 lives. And I don't know about you, but as for me, Your Honors, every life is important. Every action that we take as a community is important for a better tomorrow. I would always rather say that I tried to do something instead of nothing, and that inaction is action, and that by us not doing anything as a community, we become partially responsible for the problems that happen to our kids when they end up in the wrong place at the wrong time. So to Resnick Hoffman tonight, I would respectfully say, be thankful that there was a juvenile curfew ordinance. To Resnick Hoffman tonight, I would respectfully say, be thankful that there was a police officer concerned enough to take out her time, to take him out of a place of danger and put him in a place of safety. Because if it wasn't for the juvenile curfew ordinance of the city of Amherst, Your Honor, Mr. Resnick Wayne Hoffman might not even be here today. And for that reason alone, I respectfully ask this court to reverse the decision by the Supreme Court of New Columbia and find that the juvenile curfew ordinance is constitutional, and help us help ourselves in saving our children from the streets. Thank you.
Thank you, Counselor.